Hi, I'm Savage with International Risk Resources, and this is Reservation of Rights letters. What are they? What do they mean? And what should I do to protect myself? The insurance company has crafted this letter to let you know that they might not be providing insurance coverage for that claim. And they provide a list of what seems to be every exclusion in the policy, sometimes up to 40 pages. It's a strongly worded letter to let you know you might be on your own. While this letter is written in the insurance company's best interest, it is obviously not in your best interest. So let's take a look at 10 things you can do to help protect yourself. Number 1, notify your claim administrator. And if you don't have a claim administrator, we recommend that you get one, because these are claim specialists that work for you, not the insurance company. Number 2, you need to respond immediately. You need to let the insurance company know that you disagree with their potential coverage position, and let them know that you'll get back to them after an investigation has been completed. This reply is necessary because your silence can be used against you. Number 3, demand a full investigation. Facts are obviously important, and sometimes it seems that facts vary by the party collecting them. Other times, you may find that critical information is just simply not pursued, perhaps because it wasn't in somebody's favor. This is why you need an investigation done on your behalf. This way, information that would benefit you can be pursued. Essentially, we're looking for facts that will expand the insurance company's duty to defend you. Number 4, your insurance company is required to operate in good faith. Now, what does that mean? That means that they must put your interests before their own. And for the most part, that happens. But there are occasions when you need to just confirm that your interests are being put before theirs. Number 5, the Reservation of Rights letter will demand that you comply with all reasonable requests and that you cooperate in their investigation. Now, obviously you want to be in compliance with the policy requirements and criteria. And the policy does state that you need to cooperate with the insurance company, and we want to do that. But we also have to keep in mind that they are reserving their rights to deny coverage. It's an adversarial position, and that needs to be considered when you're doing this cooperation. We need to cooperate while still maintaining your rights and interests. Number 6, prepare to wait. The insurance company is not going to be in any hurry to provide you with the results of their investigation or to make their coverage determination. You're going to wait. So it's a good idea to maintain a pretty detailed diary of when you contacted the insurance company, when they contacted you, what they requested, when you sent it, and when it's time to just follow up and say, oh, I sent you this thing 2 months ago, what's going on here? What are we doing? So you can keep the ball rolling on this. Number 7, beware of requests to sign waivers or agreements of any kind. Occasionally you'll be asked to sign a waiver that is required for them to provide you with a defense attorney, for instance. But this is a case where you'll want somebody to take a look at it, a claim administrator, for instance, to determine, is this a good thing for you to do? Is this in your best interest? Because don't forget, waivers and agreements with your signature on them can have long-lasting consequences and aren't always in your best interest. Number 8, independent counsel. If the insurance company is suggesting that some of the things in the lawsuit might be covered and some of the things in the lawsuit might not be covered, then you might be entitled to independent counsel that's appointed by the insurance company. But consider this. If the insurance company has appointed the attorney and the insurance company is paying for the attorney, who exactly does that attorney work for? Number 9, risk management. Now, it might sound a little funny to bring up risk management as a prevention for something that has already happened, but there's a lot of information to use here to your benefit. Number 1, you've got the Reservation of Rights letter and how the insurance company responded to it. You've got the incident that actually developed the Reservation of Rights letter to begin with, the lawsuit. And then you also have an in-depth investigation, one done by the insurance company and perhaps one done by you. So that's a lot of information to use to determine what can you do in the future to prevent this kind of thing from happening again. And number 10, ditch the deductible and get a self-insured retention. With a deductible, The insurance company has all the control over your claims. You submit the claim to the insurance company, they adjust it, they appoint the attorneys, they settle the case, and then they send you a bill for whatever it is that they determined you owe. With a self-insured retention, it happens the opposite way. You are in control entirely up to the point of your self-insured retention. You can decide if you want to pursue the claim, if you want to fight the claim, if you want to pay the claim, which attorney you may or may not hire, which investigator or expert you may or may not hire regarding the claim. It's all up to you, and you can refer to your claim administrator to help make those decisions, what would be in your best interest. A self-insured retention is a powerful way to gain control over instances like you might be experiencing right now. Well, that wraps up our list of 10 things. I hope you found it was helpful. I've been Sean Savage with International Risk Resources, and I'd invite you to either contact us at the information on the screen or leave a comment below. I appreciate your view and look forward to seeing you in the next one.